You're sitting in a quiet parking lot, finishing a phone call. Or perhaps you're walking through your own neighborhood at dusk. Suddenly, the spotlight hits you, or an officer steps onto your path. The request, polite but firm, cuts through the air. I need to see some identification. Your pulse quickens. A flood of questions rushes in. Do I have to comply? What happens if I refuse? Can this get me arrested? In this pivotal moment, your response carries weight far beyond the immediate interaction. It represents the practical exercise of constitutional rights that define American liberty. This isn't about finding a clever loophole or being confrontational. It's about possessing clear, accurate knowledge of the legal boundaries that govern every police encounter. Let's be unequivocal. Misunderstanding your rights can have serious, real-world consequences. Introduction: the intersection of daily life and constitutional rights. The dynamic between a citizen and a law enforcement officer is one of the most fundamental and often most intimidating interactions with state authority. It occurs countless times daily across the United States. For the officer, it may be routine procedure. For the individual, it can feel invasive, confusing, and overpowering. The simple demand for identification sits squarely at the crossroads of the Fourth Amendment's protection against unreasonable searches and seizures and the Fifth Amendment's right against self-incrimination. Popular culture, however, is saturated with misleading advice and dangerous oversimplifications, often presented in sensational online videos that prioritize clicks over correctness. The legal reality is nuanced and, critically, varies significantly by state. No single, magical phrase works universally. True empowerment stems not from a memorized script, but from a foundational understanding of the principles involved. This article will dismantle common myths and construct a framework of authentic, citable legal knowledge. We will examine the 3 recognized levels of police encounters, the crucial concept of stop and identify statutes, and the precise, respectful language you can use to safeguard your rights without escalating tension. This is not about hostility. It's about informed citizenship. Part 1. The legal framework. The 3 tiers of police encounters. To know how to respond, you must first recognize what is legally occurring. U.S. courts define 3 distinct categories of police-citizen contact, each with different rules. Consensual encounter, or voluntary contact. This is merely a conversation. An officer may approach you in a public space, ask questions, and request your ID. The core legal principle here is that you have the right to decline. You are free to say, "Officer, I don't wish to speak," or ask, "Am I free to leave?" If the answer is yes, you may walk away. In a purely consensual encounter, there is no legal obligation to provide identification or answer questions. You have not been detained. Your refusal, while lawful, may prompt the officer to develop reasonable suspicion, potentially leading to a detention. Investigatory detention, or a Terry stop. From Terry versus Ohio, this is the stop and identify. Here, an officer possesses reasonable, articulable suspicion that you have been or are about to be engaged in criminal activity. This standard is more than a hunch, but less than probable cause. In this scenario, you're not free to leave. This is a temporary detention. It is at this juncture that state-specific stop and identify laws become relevant. The officer may also conduct a limited frisk for weapons if they suspect you are armed and dangerous. Arrest. This requires probable cause to believe you have committed a crime. You are now in custody. Your Miranda rights, the right to remain silent, the right to an attorney, are firmly in effect. Identification is typically processed during booking. The critical transition in most street interactions is from a consensual encounter to an investigatory detention. Correctly identifying which is occurring is paramount. Part 2. The core issue: stop and identify statutes. This is where the myth of a single national rule collapses. The duty to identify yourself when detained is governed by state law, following the Supreme Court's 2004 ruling in Hybel v. 6th Judicial District Court of Nevada. The Hybel decision. The court upheld Nevada's law, confirming that states may require a detained individual to identify themselves during a Terry stop and that providing one's name does not automatically violate the Fifth Amendment. The state-by-state patchwork. Consequently, the law is a complex mosaic. States generally fall into four categories. States with explicit stop and identify laws. Roughly half of the states have statutes that explicitly require a person detained under reasonable suspicion to provide their name, and often additional details like a date of birth or address. Refusal can be a separate crime, usually a misdemeanor. Examples include Nevada, Arizona, Ohio, and Florida. States relying on court interpretation or obstruction laws. Some states lack a specific statute, but have court rulings creating a similar duty or may use broader, obstructing an officer, or failure to comply charges. This area is highly nuanced. States with no general obligation. Outside specific contexts in several states. There is no general legal duty to identify yourself during a detention unless you are operating a vehicle, carrying a concealed weapon, or in a specially regulated area, e.g., an airport. Examples include New York, Pennsylvania, and Massachusetts, though local practices can vary. The universal rule, driving. Across all 50 states, you must provide a driver's license, registration, and proof of insurance during a lawful traffic stop. This is a separate, well-established requirement. Part 3. The Practical Guide. What to actually say and what to avoid. With this understanding, we move from myth to practical application. The goal is politeness, firmness, and legal precision. Hostility almost guarantees a negative outcome. Step 1. Clarify the nature of the encounter. Your first and most crucial question is about your status, not your ID. Calmly ask, "Officer, am I free to leave? Or am I being detained?" If the answer is yes, you are free to go. You are in a consensual encounter. You may choose to cooperate or simply say, "Thank you, have a good day," and leave. Providing ID in this context often ends the interaction swiftly, but you're not legally compelled to do so. If the answer is no, or the question is evaded, you are being detained. The officer must have reasonable suspicion. Your state-specific laws now apply. Step 2. If detained, ask for the reason. You have a right to know why you're being detained. Ask respectfully, "Can you please tell me the reason for my detention?" This requires the officer to articulate their reasonable suspicion. It is a reasonable and non-confrontational question. Step 3. Responding to the ID request. A calibrated approach. Address the request for ID with informed clarity using a question. Say, "Officer, under what specific authority are you ordering me to provide ID? Or is that a request or a lawful order under a stop and identify statute?" Why this works? It is legally precise. It shifts the dialogue from a power dynamic to a discussion of authority. In a stop and ID state, the officer should be able to cite the basis. In a state without such a law, this question highlights the potential lack of legal grounding for the order. Potential outcomes. The officer's response dictates your next move. If they cite reasonable suspicion of a specific crime, e.g., you match a burglary suspect's description, and you are in a stop and ID state, you are likely legally required to provide your name. Refusal could lead to arrest. At this point, providing your name is often the most prudent action. You can then explicitly invoke your right to remain silent regarding all other questions. If they cannot cite a crime, or you are in a state with no ID obligation, you might state, "I do not believe I am legally required to provide ID in this detention. I am willing to cooperate if I am free to go." This carries risk, as the officer may arrest you, forcing a legal challenge later. Critical do-nots. Do not lie or provide false identification. This is a crime everywhere. Do not physically resist, even if you believe the arrest is unlawful. Your challenge belongs in court, not on the street. State your non-consent verbally. "I do not consent to any search," or "I am not resisting, but I do not consent to this detention." Do not argue legal technicalities on the scene. Your objective is to de-escalate and gather information. Do not make sudden movements. If you choose to provide ID, narrate your actions. "My wallet is in my back pocket. I'm going to reach for it now." Part 4. Beyond identification. your inviolable rights in any situation. The ID question is one component of your broader rights, which you always retain. The right to remain silent. You have an absolute Fifth Amendment right to refuse to answer any questions beyond identifying yourself, if required by law. The effective phrase is, I am invoking my right to remain silent. I will not answer any questions without an attorney present. Say it clearly, then remain silent. The right to refuse searches. You have a Fourth Amendment right against unreasonable searches. If asked for permission to search your person, car, or belongings, you must state clearly, I do not consent to any search. This preserves your legal position. Note, an officer may still perform a limited pat-down for weapons if they have specific suspicion you are armed. The right to an attorney. Once you say, I want a lawyer, all questioning must stop. It is a simple and powerful invocation. Conclusion. Inform composure as the highest form of civic responsibility. There is no secret password. The true correct response is a series of calm, legally informed questions that clarify the encounter's nature and the officer's authority. This knowledge does not make you a provocateur. It makes you an engaged citizen who understands that rights neglected can become rights eroded. Our system relies on checks and balances, and your informed participation is a vital component of that balance. Carry this understanding not as a weapon for defiance, but as a tool for ensuring the law is applied justly, consistently, and correctly for you and for all. A final, personal observation in the requested personal opinion style. After extensive analysis of these encounters, what resonates most is not the legal intricacy, but the profound strength of a calm and informed presence. The citizen who understands the legal framework is not an adversary to public safety. They're a participant in ensuring lawful policing. The greatest danger in these moments is not a question about rights, but either blind compliance that allows overreach or belligerent ignorance that sparks unnecessary conflict. Our civic duty includes knowing the rules that govern our interactions with authority. That knowledge is the quiet, essential force that maintains integrity within the system. Engaging question for the audience. Considering the significant variation in state laws regarding identification during police stops, do you think the United States would be better served by a single, clear federal standard, or does the current state-by-state approach more effectively respect principles of federalism and local governance? Share your perspective and reasoning in the comments below.